Good afternoon, everyone. My name is Lisa Maldonado, and I am serving as your hostess for this session, and I have the ribbon to prove it. I am pretty excited about this session. I am from Lee County, Florida, and I oversee the criminal division, and we've instituted criminal case management back in 2008. And this is a great opportunity to hear the latest and greatest. We have an excellent panel from the National Center for State Courts here with us today. First, I would like to thank each of you for the work you do. I'm always so impressed with all of the research and the availability that you have to each of us, so thank you. I would like to remind everyone that if you have any questions or comments, please use the microphone as this session is being recorded and live streamed. Okay, I'm going to go ahead and start by introducing Dr. Scott Graves, that's here with us today. He is a court research associate with the Research Division of the National Center for State Courts. He joined the National Center in 2011, and previously he was faculty in the Political Science Department of the Georgia State University, specializing in judicial politics and research methodology. He is the author of articles on state criminal justice, election, litigation, antitrust in the courts, and a book about judicial recess appointments. His work with the center has included evaluations of problem-solving courts and other judicial programs and policies, data collection, using complex survey and sampling methods, case and workload forecasting, risk assessment, model building for incomplete data structures, and simulation. So welcome and thank you. Also with us this afternoon is Dr. Nicole Waters, a principal court research consultant, has been with the National Center for State Courts since 2000. Current work at the center includes research on problem-solving courts, examining the appellate court case processing, and evaluating policy implications of jury procedures. Dr. Waters is currently conducting an evaluation of the Miami-Dade Adult Drug Court Program and developing performance measures targets for Kentucky's drug courts. She has explored mental health courts both statewide and nationally, including a statewide evaluation and development of statewide standards for mental health courts and development of national performance measures for mental health courts. I got that out all in one breath. Welcome and thank you. Also with us today is Ms. Cynthia Lee. She is a senior court research associate at the National Center for State Courts, specializing in program evaluation and workload assessment. Current projects include judicial workload assessments in Florida, Wisconsin, and Maryland, a NIJ, National Institute of Justice, funded evaluation of holistic defense practices in public defender programs, and a national study of criminal case management funded by the Laura and John Arnold Foundation. Ms. Lee has recently served as Director of Research for a multi-method evaluation of the Nebraska Parenting Act and as a Project Director for the West Virginia Magistrate Court Workload Assessment. Thank you and welcome. I will turn it over.
Well, thank you, Lisa, and thanks to all of you for being here at 4 o'clock on a Wednesday afternoon after the snacks. You are all the true NACM diehards, so we really appreciate all of your being here. Just so we can get an idea of who is with us today, how many of you are trial court administrators and staff? Lots of folks. Do we have any judges here? One judge? And how about any attorneys? I think most of the attorneys, one attorney. 2 attorneys, and appellate court folk. Oh, over there too. Fellow attorneys. Appellate court folks in the room. So we're mostly a trial court crowd. And lastly, all of my NCSC colleagues. How many of us are here? Yay, NCSC. Okay. So today we are going to talk about criminal case flow management, focusing specifically on timeliness. And we're going to look at timeliness on 2 levels, first in the trial court and then at the appellate court. And we're going to do this focusing on one state, Colorado. Is anyone here from Colorado? And so the reason that we're picking on your state, or highlighting your state, I guess, showing off your state, is simply that it was the first state that we had trial court data for. We also had appellate court data for Colorado, so we could follow those cases up through both court levels. And finally, Colorado has the most typical structure for appellate courts on the criminal side in the country. So it provides a good example for other states. So the trial court data that we're going to be looking at today, Scott's going to show us those data, come from a study called the Study of Effective Criminal Case Management. And this study is being funded by the Laura and John Arnold Foundation, and we've just undertaken this study. So as I said, Colorado is the first state that has provided us with data that we've gotten cleaned up enough and analyzed well enough to show it to you here today. Our goal is eventually to get as many of the 300 largest counties in the United States as possible to participate in this study. So if you like what you're hearing from Scott about this study and you are interested in participating, please see us after the presentation and we can give you some information and answer any questions that you have about participating in this study. Nicole is then going to tell us about what happens to those trial court cases once they go up on appeal. And Nicole's data come from a study of criminal appeals that was funded by the Bureau of Justice Statistics. And these cases are appeals that were taken in 2010. So with no further ado, I'm going to turn it over to Scott, who's going to start us off in the trial courts.
Thanks, Cynthia. I assume everyone can hear me all right? All right. As Cynthia mentioned, we are starting off with trial court, and then we're going to follow cases, not precisely the same cases, of course. The appellate court cases come from 2010. But we'll be following the criminal case process in Colorado through trial courts, and I should say trial courts, to the appellate process, looking at duration, timeliness, that sort of thing. Sort of interlocking or overlapping studies from two different projects that can give us a broader, sort of more holistic picture of duration and timeliness for criminal cases. Our trial court cases, our trial court data come from the Effective Criminal Case Management Project, sponsored by the Laura and John Arnold Foundation. We're asking for the participating courts in this study provide us with 1 year, so 12 months of data. And it's not really, it's just the most recent 12 months of data that are available. 12 months of dispositions, I should say. So disposed felony misdemeanor cases, excluding petty offenses, traffic offenses, which would give us a slightly different look at duration and timeliness. And we're asking for a substantial number of data elements, particularly the timing of various milestones, events in the course of processing the cases, the charge and the characteristics of charges and defendants, representation, pretrial release, bond, that sort of thing, and then the manner and type of dispositions of these cases. Hopefully, with all of these elements together and some analysis, we'll be able to identify where bottlenecks occur, where delay is more likely. Perhaps different structures will have different sources of delay. Identify some courts in which sources of delay appear to have been resolved, whereas other courts with similar structures and similar charge defendant characteristics are observing delays where others are not, and so we can sort of identify the hallmarks, the practices of that help some courts achieve high performance. So if you'd like to help us effectively achieve high performance in criminal cases nationwide, please feel free to contact one of us after the presentation. We'd love to hear from you. So our trial court data description follows. Colorado gave us 7 counties, which did not include Denver, but 7 of the otherwise largest counties in the state, together representing about 60% of the population of Denver. And overall, it's concluding all the felony misdemeanor cases, it's about 51,000 cases. all disposed within calendar year 2014. About 12,000, a little over 12,000 of those were felony cases that were bound over. I should preface this by saying that that Colorado, like a lot of states, has a sort of a two-tier trial court system in which misdemeanor cases and felony cases begin. Misdemeanor cases continue in the county courts, and then felony cases, after a certain a period of processing in the lower court, are bound over, and then they're disposed of in the district court. But 12,000 of our cases, which is about 60% of our felony cases in our sample, were resolved before bindover. So they're felony cases that were resolved in the county court. The remainder, the other 40%, went on to the district court and were resolved there. Our data were relational data retrieved from an administrative database, their case management system. For the most part, we'll be talking about duration in terms of active duration, which is duration from filing to disposition, subtracting out time in which the case was inactive due to parties failing to appear. About 22% of felony cases and 26% of misdemeanor cases, at some point in their duration, experienced a period of inactivity, and so that period of inactivity is subtracted from the figures that I'm going to be presenting, representing active duration. First, however, here's a picture, the one picture that I'm going to give you of total duration. These are the median days in felony cases to reach these milestones in the lifespan of a felony case. The 50% of felony cases have their first appearance within a day of filing, which is good. I'm sure the founders are smiling. Bindover, when it occurs, like I said, this only occurs in a kind of a substantial minority of cases. When it occurs, bindover occurs within 49 days for at least half of cases. Arraignment is within 128 days. And then the median total duration, the median total duration, this is including in days of inactivity, is 157 days, so just shy of 160. So inactive days are included here. From this point on, the inactive days, we don't necessarily have where they fall within the case, so they can't be taken out of the duration between events. But from this point on, when we're talking about total duration, we'll be excluding inactive days. So it's the active duration, or the period of time in which the court has control of the case. Now, to get a sort of a overall look at what durations look like in these cases, we have, and I wish the contrast between these two bars was a little bit sharper. Hope everyone can see. The blue bars represent felony duration. For the lowest two bars are the median figures, the median duration for felony and misdemeanor cases. And then the second is the 75th percentile, so 3/4 of cases have a duration that long or shorter. And then the 95th, which is really getting toward everything except the very longest cases, are disposed of within, it's just short of 2 years for felony cases. The split between felony and misdemeanor in our data were 40-60, or approximately 40-60. So this gives us a sense of what active duration, which again is the period of time in which the court has control of the cases, for felony and misdemeanor, including some of the more, giving us a sense of what the more extraordinary, longest lasting cases can actually look like. Let's see. Now, looking specifically at felonies, breaking them down by charge type, we see that Not surprisingly, homicides these are all median active durations. Homicides are the longest lasting cases. They also tend to be the cases in which the trial rate is highest. So probably not a big surprise there. And we can take some solace in the fact that they're arranged left to right, roughly in terms of the seriousness of the underlying or the most serious offense. So we have homicide, we have personal offenses, property offenses, drugs, weapons, etc. And there's something of a decline as you move from left to right. So it's the most serious cases that tend to be those of longest duration. In terms of what portion of the overall caseload these types constitute, homicide, those longest ones, is less than 0.5% of cases. So it's actually not very many, but they are the longest duration, at least in terms of central tendency. Property crimes are the most common. 37% of the felony cases are property crimes, followed by personal and drugs. Personal offenses and drug offenses are both about 22% of cases. Misdemeanor, we have a slightly different pattern. No homicide misdemeanors. I know it's shocking, but yeah, Colorado turns out considers homicide fairly serious, so they are all felonies. But among misdemeanor cases, or at least cases that are filed as misdemeanors, you see that the two longest, the two with the highest central tendency and duration are DUI and other motor vehicle. Other motor vehicle is 148. It's that one kind of sticking up, raising its hand out there in the middle. And DUI has the second longest average duration expressed by the median. Those are also roughly 12%. To combine, those are about 12% of misdemeanor cases. Personal offenses actually are the most common misdemeanors. They're about close to 30% of the caseload is personal over on the far left. And they also tend to be some of the longer cases among misdemeanors. So if we think of those as being among the most serious offenses, they also tend to be among the longest, but DUI and other motor vehicle are also tend to be pretty lengthy. Colorado has actually incorporated an expectation that DUI cases will be somewhat lengthy into their own statewide voluntary model standards.
When you're talking about other motor vehicles, are you talking like reckless driving? I know you excluded traffic.
Yeah, we've excluded traffic, at least non-misdemeanor traffic. So misdemeanor traffic are included in our data, and it would be things like reckless driving, that sort of thing. Now, so this gives us sort of a broad overview of what the landscape of case durations look like. Now, to turn to the model standards by which we might judge these, a little history on model standards for trial court durations. The ABA got started promulgating model standards for trial court criminal duration in the late 1960s. They amended theirs in 1984 and again in 1992. The ones that we're going to be relying upon were promulgated in 2011, that's right. So they're about 5 years old. They were produced by COSCA and have been adopted by, among others, CCJ and NACM. So, and the ABA. So we have about 5 year old standards that are informed by data. Although a lot of the studies that have been done up to this point on looking at criminal case processing time have been confined to urban courts, large population courts. With ECCM, we're looking to broaden somewhat our field of vision in terms of case duration. And the 2011 standards follow a tripartite model, which is informed by differentiated case management. So as courts have sort of focused, have used differentiated case management as a focus for organizing dockets and resources, the model time standards also follow along in a similar fashion. Idea behind this being that different types of cases or different cases will require different degrees of judicial intervention. And it's that judicial intervention or the necessity for that judicial intervention, how much processing or managing by the court really needs to be done in order for a case to be resolved. That's what leads to well, I hate to call it delay because sometimes cases just take as long as they take. But cases that require more issues to be resolved in order for the parties to come to an agreement, or that require a judicial disposition in terms of a trial, they just need longer. They need more time. They need to be longer. The idea being that about 3/4 of cases require very little judicial intervention. They're primarily driven by the attorneys, and they can be resolved without many issues being resolved. 75% of those cases, therefore, should be resolved fairly soon, within a fairly short period of time. The next tier, which constitutes a cumulative 90% of cases, may require some judicial intervention to resolve some small number of issues. And those cases will be resolved within a somewhat longer period of time. And then you got another 8% of cases that will require substantial judicial involvement. And so the third standard, which together comprise 98% cumulative of cases in felony and misdemeanor, what should meet a third standard. And then there's another 2% on top that have that are going to be extraordinary in some fashion. And those are just kind of inevitable. So that small group of complex, consequential cases are going to require more time. In criminal context, often that means death penalty cases. The specific standards are as follows. For the felonies, the idea is that 75%, this first sort of minimal judicial intervention class of cases, should be resolved within 90 days. Another 25% will take longer. Of those, another 90% cumulatively will be resolved within 180 days. And then that 98%, everything except for the most extraordinary cases, resolved by the end of a year. For misdemeanors, the same proportions are applied, but the durations are slightly shorter. So 60 days, 75% of cases resolved. 90 days, 90% of cases resolved, and then everything but the most extraordinary cases resolved within 180 days. So how do Colorado's data compare to these standards? We see we have 3 lines here that that constitute the 3 standards. There's 90, 180, 365, and these are felonies only. These are durations for felony cases, and each bar is the proportion of cases resolved within that time period. 90, as you can see, the bars should line up with those black vertical lines. Of course, they all fall short. The standards are sort of aspirational to some degree, but we do see that the longest bar, the 365-day portion, are reaching into the 80% plus range. So, I'm sorry. Yes.
Yes, I just have a question about your last slide.
Sure.
So, with these time goals, are we taking into account the complexity of the case, or is this an overall general time goal? For example, when we implemented our case management system, we do have distinct tracks with expedited, standard, and complex. So I'm just curious as to how that works?
Well, the proportions themselves are supposed to incorporate sort of an idea of how many cases are going to fall into these different different tiers. The idea being that roughly 90%, like to take one example, roughly 90% of cases are not going to be among the most complex. And then the fact that the longest standard only constitutes 98% is sort of recognizing that there's going to be some 2% of cases that are just going to defy expectations. Using a triage or some sort of flagging or tiering of cases in order to perhaps introduce early judicial administration should be an attempt to try to make cases fit into sort of right sizing so that they fit into the standards, the standard in which they belong. But the 75%, 90%, 98% figures sort of in recognition of the fact that some portion of cases are going to be very easy to resolve, others are going to be more complex and require more time. So for misdemeanors, trials, virtually no trials in misdemeanors. Sorry? I'm on felonies. Okay. Oh, I'm sorry. Yeah, I'm sorry. I switched from. Okay. Yeah. Yes. This black bar is the 90-day point, and this is the proportion of cases disposed within 90 days. So if the cases were meeting the standard, then the blue bar should come up to here, the gold bar, or tan, I suppose, should come up to here, and then the gold one would come up to here. So this is like 75%, 90%, 98%. The cases are divided into manner or by result, the result of disposition. So up top we have convicted, in which the defendant was convicted. Acquitted is next. Deferred and dismissed are the final two disposition results that we see. Acquitted, of course, only occurs via trial, so it's probably not a big surprise that the proportion of cases that are that result in an acquittal disposed of within 90 days is vanishingly small. Convicted, of course, combines those trial outcomes and also the much more common pleas or common pled cases. That's why we break them down also by the manner in which they're disposed. Trials are on top, pleas next, and then the other two are the same figures that we saw in our last slide. As we can see, trials just take a long time, but the third bar, the cases disposed of within a year, reaches pretty close to the standard, much closer, say, than the second tier. Pleas are resolved much more quickly. You see the same figures for misdemeanors. The standards are aspirational. The bars are not really reaching those, but the third tier, sort of longest duration that fits within the standards, are approaching 80% in each case. Let's see. Yeah, pleas represent for misdemeanors about 45% of outcomes, of case outcomes, and dismissals for misdemeanors are about 37%. Now, as I mentioned before, Colorado has its own voluntary standards imposed in 2000 or introduced in 2008, and they function in a similar fashion, but only focus on sort of one standard. The district court, which handles felonies, 95% of cases should be disposed of within 1 year, which is fairly close to what the COSCA standard is. It's 98%. County misdemeanor, the misdemeanor cases, they look for 90% of cases to be disposed within 6 months. Excuse me. And they also recognize the 7-month standard. They have a 7-month time standard for DUI or DWI cases, with a recognition that, as we've observed in our data, that those cases tend to be a little bit longer. Among misdemeanors, DUI cases, they were among our longest lasting cases. So they have a separate standard for that. Now, to lead us into our appellate analysis, we can look at cases which are sort of eligible for appeal. If we think about felony cases as being particularly likely to be appealed, and then focus on cases in which someone's convicted at trial, either by jury or bench, we can see, starting with the full felony caseload, by the time we've removed all the cases that would not result in an appeal, we've narrowed it down to about 450 cases. Yeah.
Sorry, going back a little bit on the DUI cases in Colorado. Are there like mandatory sentencing laws? There are. Okay, so that's what's driving the length.
Yeah.
By and large. Okay.
Yeah, I imagine
Sorry, it just
it's,
helps have the context.
Yeah, I imagine it's probably stakes. Yeah.
Are they more likely to go to trial?
I think they are, but yeah, I think they are more likely to go to trial, which is sort of a recognition of this. Now, this is only 7 counties. Like I said, 60% of the population are in those 7 counties. So if we think about this as being about 60% of appealable cases that are produced within a year, it's closer to between 700 and 800 cases overall produced that are within that sort of appealable pool, likely to end up in the appellate courts. Now, this is focusing just on those felony trial convictions. These are the durations of those cases, and this is the median durations, and they all tend to be pretty long. Surprisingly, the longest median duration is legal process. I'm not sure how likely those are to be appealed, but this just focuses entirely on trial outcomes in felony cases.
What is the legal process for?
A lot of that is like probation violations, avoidance of process, and but should say that there are not very many of them in our felony caseload. It's a very, very small proportion. Person is 48% of the cases in this class right here of these trial convictions, felony trial convictions. Person is nearly half of the cases in this class. Property is another 20%. Drug and homicide are both about 10-11%. The rest of it is all change, really. But this leads us to our appealable cases. So we can pick it up now with Nicole looking at appellate processing.
Thanks. So I'm going to step away from that. Hopefully you can hear me okay. Let me start off by saying that Cynthia asked you all who's here from the appellate courts, and nobody raised their hand, right? So why do you want to continue to listen to me for the next 20 minutes? Why do you think this matters? Because it can come back. Why else? Okay. Okay. Yeah, Scott. Oh, you're the same.
I was going to say it's just for context.
So people are answering that this is for context, and because they care, because they're from the AOC, and because it could come back to them. Yeah.
We just care about time and justice.
We care about timely justice. Thank you very much. So one piece that we're trying to do here at this presentation is to make sure that there's this interplay and understanding that is really the perspective of the defendant, right? So the defendant is going through the entire process, and we care about it because we want that person to be able to get timely justice. We want them to be able to get fair and equitable justice too. And there's a balance there between the two of them. So when their case is not necessarily over at the end when they are sentenced or convicted or maybe acquitted, but instead it's now going through the appellate court process, and they become an appellant or petitioner, and they might go through this long, very, very long process. So if it takes them, a year, 2 years to get through the trial court, and then how long does it take them to get through the appellate court? It's still their experience, right? And that's what the courts are all about. We're there to serve the public and make sure that that perspective is taken into consideration, that we treat them like customer service, right? So that's why I think you should care. But one other piece why I think you should care, and I'm going to get to it later, is because the appellate courts, when asked what's the longest source of their delay, they pointed to you all. It's your fault. So that's why you should also care. Hopefully we can work through some of those issues and talk about where that comes from. And I'm going to share some data with you, which is really exciting. So the appellate data comes from a study that we've finished a while back. We're starting to publish on it and do some presentations with it. It includes the very first look at a national perspective where we investigated, we read through at the very bottom here, the case files, the briefs, and the opinions for over 5,000 appeals nationwide. We did this for every single appellate court in the nation that has criminal jurisdiction. So there's 143 courts. A lot of work, by the way. But it gives us rich data that we're just starting to exploit, and I'm really excited to do that. Just so you know, there is a bulletin that we wrote back in the fall, and that's available online. There's also publications that I've tried to scatter out. There's some outside and there's some up here. Talking about, this one specifically talking about timeliness. It's also available online, but feel free to pick up a copy if you'd like. So it's the very first time we've been able to do this, and it's such rich data, we haven't been able to explore it fully, and I'm really excited to at least focus right now on the timeliness part. We looked at only direct appeals of a sentence or a conviction. That means we admitted the post-conviction, the writs, the interlocutory appeals, and we looked at 2 levels of appellate review when the appeal went through the Intermediate Appellate Court and the Court of Last Resort. It had 2 levels of review. We were specifically interested in those, so we did an oversample of that. And then I just mentioned there was a sample, so the 5,000 was a sample of all of those cases that were disposed of in 2010. And so we can estimate that up using weights to get to nearly 70,000 appeals. How are they resolved? Looking at the 5,000 total appeals, what's different about the appellate courts than the trial courts is that there's more judicial interaction here than you tend to see at the trial court level. 63% of them were reviewed on the merits. And you can see 52% affirmed, which I think is a good indicator of what the trial courts are doing. I think the trial courts are getting it right, which is great. 12% are reversed, remanded, or modified, or some combination of those, are being sent back to you. And then not reviewed on the merits, there's about 1/3 of those. And typically these are ones that are being dismissed for procedural reasons. They're not filing on time. Also under discretionary review, they might not be granted review. So taking that structure of how they're disposed, so we've got 63% are reviewed on the merits. If we break that up and look at the blue bar is on the merits and the beige bar is not on the merits, you can look at the timeliness of this review. And you can see that at the 50th percentile, that means half of them are resolved at that point, 75th and 95th percentile. Obviously, when they're reviewed on the merits, they take more time. If they're not reviewed on the merits, we can resolve these pretty quickly. But if we just look at that median there, it's just over a year to resolve half of the appeals that are reviewed on the merits. And that's the one I want you to focus on right now. So pulling that a little bit further, thinking about the milestones that occur in the appeal. Breaking it down by when it was first filed to when the record was complete and filed and the transcript was complete. So who's responsible for the record and the transcript? The trial court, court reporters, So now the appellate courts are saying this is not within our control when asked. This is something that's going on down below, or the court reporters have a lot of control over it, and there's a lot of tension there as to who's responsible for the potential delay. The next stage is the briefing stage. So this is the time between the initial brief being filed and when it's complete and perfected, ready for the court to review it. And who's responsible for that? The attorneys, right? So the appellant or the petitioner and his or her attorney is responsible for that. So they go back and forth and brief all the issues. There might be an oral argument to present to the court. Once that is done, then it goes to the judges and the justices, and there's a decision made. So there's a review, writing the opinion in that process. So that's the part that the appellate courts say they are responsible for. Now these are proportional, so you can tell that that does take the longest for 50% of the appeals. And I'm including here on the merits and not on the merits. Now if I take out those not on the merits ones and just those that are granted review or those that have no procedural issues that can go forward, those numbers change drastically. So I'm going to look at that a little bit. But overall, start to resolution, 50th percentile or the median is just under 1 year, 297 days. So it's important to talk a little bit about some structural and procedural differences. Appellate courts have responded to some changes and have, because of those changes, they've implemented some different structural and procedural responses. One in particular is introducing the intermediate appellate court. So response to workloads, perhaps they can't handle it all, so they're creating an intermediate appellate court to have jurisdiction over some of these cases. They want to increase access. They might be putting out different geographical divisions so people don't have to travel all the way across Texas, for instance, to get to an appellate court. There's also discretionary jurisdiction, and what that means is if you have a right to appeal or if the court gets to decide whether you hear this by permission. So introducing that nuance helps to reduce your caseload, right? And then rules for assignment, whether it's a panel of judges, a small group of judges or justices, or whether it's heard by all of them en banc. And all of these things affect timeliness, is what we're finding. So on our webpage, we have structure charts, and it just lays out what type of review and which courts and so on. And so as Scott had mentioned, here we have the county courts and the district courts. And then you get up here into your intermediate appellate court, called their court. They call it the Court of Appeals. And then there's the Court of Last Resort, which is called the Supreme Court in Colorado. So I wanted to throw that up there to just give you a sense of the structure that we're going to be talking about. So that means that there is a possibility that you'd have two different tiers, just a Court of Last Resort or a Court of Last Resort and an intermediate appellate court. So this is the map of the states. And the gold ones are the ones that have two tiers. So the majority do. And you can see a theme here, right? The blue ones tend to be more of the rural jurisdictions. Keep in mind, this is for criminal appellate review, so there's a difference with the civil. And it's also 2010, so there's been some changes that are noted here. So like, for instance, Nevada has implemented a intermediate appellate court that was not there when we did our study. So if I take that tier part, and I also add into it the discretionary review piece or the by right, by permission piece, we can come up with 7 different categories or ways to think about the structure, which I think is meaningful. And I think it's helpful to try to think about the different structures and what kind of a impact that might have on timeliness. So the gold ones are most common, and those are the intermediate appellate court has mandatory jurisdiction primarily, and the Court of Last Resort has primarily discretionary jurisdiction. And that's where majority of the courts are falling right now. You can also see, if you recall from the blue states here, they're now mostly gray here because they're the Court of Last Resort, only one court, and it's mandatory review. So I'm going to take those 7 categories and now talk to you a little bit about timeliness by the structure. This is the 75th percentile. And you can see there's not a whole lot of variation, and I see that my numbers aren't popping up there for some reason. That's too bad. It must be a version control. So just to give you the numbers, 362 is the top number. So it's just shy of 1 year. And the next number is 515, which is just shy of the 18-month mark. The very bottom one down here is 553. So you can see there's not a whole lot of variation here, but we're talking about somewhere between a year to a year and a half for 75% of them. Also, I have added in parentheticals there the percent that were heard on the merits. Remember how that mattered before? So I put that there. And as you can see, the IAC and COLRs with discretionary review both have predominantly discretionary review, only reviewed 25% on the merits. And the COLR mandatory down here was 78%. 78% meaning they hear them just by right, but keep in mind that there's that piece that I showed you in the very beginning, which is not all of them have all of their papers together. Some of them are dismissed because of procedural errors, so that's going on down there. But generally speaking, the ones that are taking longer also have mandatory review. And it's even more apparent when you throw in the 95th percentile here. You can see that there's this nice pattern. But now we're nearing the 1,000-day mark. So that means that 5% of them are still not resolved at that point when we're 2.5, 3 years out. So what does that mean for the appellant? And that's waiting for the answer. That's bad news. So what do we do about it? Well, one thing is that we try to look at what are the model time standards. As Scott presented the trial court time standards, ABA put together some model time standards. I'm going to go through this fairly quickly just for the sake of time. But basically, in 2014, they just released some new time standards with these different groups funded by SJI. So that's available online. But here's this piece that I was telling you about at the very beginning. Most appellate courts identify the transcript record preparation stage as the largest one of contributing to delay. They're organized in a very, I think, complicated way, taking into account all sorts of different things like the tiers, the review standards, the underlying case type, the different events, whether or not it was granted or denied review, if that was a part of the process. And then they present it in 75th and 95th percentiles. And here's the big part that I think is interesting is they have not only standards presented, but also progressive benchmarks. So 50%, the level 1 benchmarks, all courts should reach that level. Level 2 benchmarks, 50% of the appellate courts should reach that level. And the standards, they're hoping that we get there someday. So what does that mean? That means that they're taking this and giving you a lot of chances to meet these standards. Many, many years can go by where you're still trying to work towards these standards. So it's really not very restrictive. And we can see that some of this was based on actual data that was used to determine what these levels should be. But I'm going to show you some of the data and how it compares. So as you recall, Colorado here, that's our case study, and it's the most common. So I'm just looking at the intermediate appellate courts by right. And I'm comparing that national number. You can see they just barely made level 2. Colorado, unfortunately, is over here at 910 days for the 75th percentile. So I broke it down a little bit further by the milestones to try to see where is that delay coming in. And for Colorado anyway, the record transcript preparation, the briefing, is where their delay is happening. The decision is not where it's happening in comparison to other like appellate courts. So what did we do? I actually went out and reached out to the Chief Justice and the clerks there at the Court of Appeals and asked them what was going on. And they admitted, yes, in 2010 we had problems. And we have implemented some solutions to deal with that. And it's been 6 years now, and what I'd love to do is to ask them for more recent data to be able to compare to see whether or not these changes made an impact on their numbers. They believe that their numbers are better. So they had some resource issues. They just hired 12 new staff attorneys with their Attorney General's office. So they went to the legislature and got additional attorneys to help with some of this. They also have been rolling out e-filing in their district courts and also digital transcripts to help with some of the delay. They've also been putting in different policies for dealing with extensions and how those are reviewed, and they're becoming a little bit more strict about those. What's interesting is that they said to me that the people who are asking for extensions and excessive briefing and so on, now that we've got new attorneys, these 12 new attorneys, they're under a new culture. And so they aren't asking for those things because they aren't part of that culture that expected it. So there's huge culture change happening at the same time that some of these changes are being implemented, which is really interesting to see the interplay between them. They also are checking to make sure the record's complete as opposed to waiting until they're ready to review everything and then say, oh, oops, there's something missing. Now we have to wait until that record is complete. We can't really get going with the briefing piece. And here's one of my favorite ones that they were talking about, which is a cost deduction policy. So the court reporters, the number of days that they are late, they start deducting their fee. So if you're 30 days late, you get 75% of your fees. If you're 60 days late, you get half, 50%. But they found one really interesting little twist to this, and that is that the incentive after 50% plummets, and they would just not get them. Because they'd rather work on the ones that they think they can actually complete, right? And so it backfired at a point. But at the same time, they were very effective at getting a lot moving. And so they're working on how do we meet this right balance to keep incentivizing them, but also to have some sort of a penalty in place, which is really neat. So I'm going to turn this back over to Cynthia to hopefully invite some discussion about this.
So based on the data that, can everyone hear me? Okay. So based on the data that Nicole and Scott have shown us today, it looks like it's pretty difficult for courts to meet these model time standards, right? So for our effective criminal case management project, we are in the first phase of this project right now, which is just collecting data to look at timeliness, not only the timeliness of disposition, but also the timeliness of some early case events like the appointment of counsel and the initial appearance, the arraignment. Once we have done that, we are going to identify courts that appear to be especially timely, especially efficient, especially effective at case management, and we're going to identify about 8 courts. And we're going to look at those courts and ask, why are they so effective? What practices have they implemented that have made them effective at managing their criminal cases? So to give us kind of a little jump start on that phase of the project today, we'd like to ask you if there's anyone here whose court has implemented a system for identifying delay, and what is that system? How do you identify delay? How do you address it? And how has that been working for you? So is there anyone who has anything to share with us? Lisa, do you want to share what your court is doing? Can you go to the microphone, please, because it's being taped. Thanks.
Okay, so we started, as I mentioned, in 2008, and we quickly realized that the most important thing for us was the data collection and really fully understanding our issue. And so at the time, we had a number of backlog cases. I would say we were in a crisis state. And so I guess to specifically answer your question, I think the most important thing is the statistics and the data, and we share age pending reports with our judges regularly. We highlight those cases that in our particular jurisdiction, as I mentioned, we have the expedited, standard, and complex. So we highlight those cases that are over 365 days, and that is, our hot list, and we're looking at all of our criminal justice partners are looking at those lists regularly to identify any issues that can potentially enable the progress of the case. So we're sharing those reports. We do have case managers aligned with each of the judges, and that has made a tremendous difference, where they are maintaining notes of each court event. So if a judge is indicating that, for example, in Florida, we have depositions, which tends to be a big cause of delay. So if the judge indicates that those depositions should be taken care of before the next court hearing, the case manager is taking notes accordingly and reminds the judge, and the judge at the next court hearing has those case notes in front of him or her and is able to hold the attorneys accountable as far as that goes. Did I answer your question?
Yes, that's great. And so you're from Florida.
Yes.
And we just did a judicial workload assessment in Florida. We did site visits to, I think, 8 different courts. And when we asked the judges, do you need more judges? Many of them actually told us, no, I don't need more judges. What I need is more case managers, because those case managers are able to identify those cases, to take those notes, to remind me what I need to do, and keep those cases on track. So it sounds like your jurisdiction is using those really effectively.
Yes.
Can you tell us about how you identify the tier for the criminal cases? How do you put them in the tiers?
Actually, at the time that the case is filed on, the assistant state attorney makes that decision. So based upon the nature and the complexity, they make those independent decisions. Now, what happens is that when it goes to what we call our case management conference, that is an opportunity for defense counsel to bring any issues to light and request that the track be modified. And then ultimately, the judge has the final call as to whether that track remains or not.
Great. Thank you for sharing. Is there anyone else who wants to share what your court is doing? Jamie?
I just have a question. I have a question for you, Nicole. We've been doing case time standards in our courts for a long time, and we've started with our appellate courts in the past few years. And I'm just wondering if you're aware of any courts that do their time standards based on the hearing of the argument to the time that they've submitted their findings.
So the time of the oral argument to the end?
As the case starts.
I do not know of any courts that have their standards based on that. One thing that was really great about the data that we have is that we did capture all of those different milestones, so we could look at that and see some of the variation across those different times and how they're measured. We calculated, for the purpose of this anyway, after the oral argument was part of the briefing stage because it's still the presentation to the court. Did you have something to add to, Richard? You have to go to the microphone.
Mike,
Yes,
Richard.
The clock starts at different times in different states, and I say this is someone who,
Can you go to the microphone? Thanks.
sorry.
I believe the answer is yes, and that the clock starts at different points in time in different states. I say this because I once was given the assignment as a rookie court person to go approach our Supreme Court in California and suggest that timeliness might be an interesting thing to look at, and got a large lecture, I will call it, on this. And we published an earlier piece called Timeliness in 5 State Supreme Courts that looked at this at 5 different places. And you know, it's a sensitive issue, right? I mean, trying to approach the appellate courts with the notion of timeliness. And that's why there's this interesting notion in the appellate standards about how they're kind of a suggestion and not so much, as Johnny Depp would say, they're not so much rules as guidelines. You know, they're just an idea that they might want to consider. So there's a lot of politics and sensitivity there, as we all know. But I think increasingly, as some appellate courts are using this and actually publishing the results like Montana does, and actually being defended in the press independently of their own doing by saying, look at our court, it's made a huge amount of progress, they're seeing the wisdom and the benefit and the of accountability in that sense. So they need to kind of get all on the same clock.
And Paula can be the last one, and then we're out of time.
Nicole, remind me, because it's been a while since I'd looked at that data. You shared with me some of the early stuff. Not all courts, or at least not all of these criminal appeals, actually have oral argument, even if there's, and what percentage actually?
Yeah, that was about 24% were resolved through an oral, or had an oral argument, as opposed to being just reviewed on the written documents.
Great. Well, we have reached the end of our time, but we will be here in case anyone else has any questions or comments. Before we wrap up, I want to remind everyone that this session was recorded. So if there are any colleagues who weren't able to be here, or you just loved it so much you want to watch it again and again and again, that video will be available. We also have party favors, which are unfortunately a little bit less exciting than the lollipops and candy that were at the vendor. Yes, and the cooler with contents that Paula got, that were at the vendor fair. But we do have the caseload highlights about the appellate data, we also have some information about the Effective Criminal Case Management Project. As Nicole mentioned, the full BJS bulletin on appellate timeliness, or the appellate study in general, is available online, and the slides are available on the conference site. So thank you so much for being here, and have a good evening.